Legal advice can be very expensive. Therefore, coming through the reduced fee clinic, my legal lab, can be a very cost-effective option. I have explained what a tribunal can be like, and here's the next hurdle: legal costs.
Before we talk about what legal advice costs you personally, it is worth understanding what the employer is actually paying for and what they are not paying for.
The whole purpose of getting legal advice from an independent direct access barrister for a settlement agreement or a lawyer is so that you can look at the terms and conditions to decide whether or not you are happy with them, or there are certain clauses that you want clarification on. I must make it clear that the payment of the fee that the employer pays to have that settlement agreement checked by an independent lawyer is not a fee to tell you whether or not you have a case against the employer. That is something separate I will come on to. So the point I'm trying to make is that you can negotiate the terms before you sign them, because all of this is outside of court. Then you have the right with your employer to negotiate the terms. Employers normally pay a fee in respect of advice received by the employee as to the terms and effect of this agreement. Now, let me explain that in some detail. Somebody is offered a settlement agreement and they come to me, and this has happened many a times, where people will come to me and say, here's a settlement agreement my employer has given me, and they've also said I can get independent legal advice on the agreement. Is that correct? Yes, it is correct, and that is absolutely correct. However, there is a caveat, and I must point that out, and this is an issue that not only myself but other lawyers, barristers, solicitors have all faced, where the employee will come and ask, do I have a case? Now, the problem there is, if the employee is asking whether or not they have a case, that is a separate bit of advice, not covered by the fee that is paid by the employer. All the lawyer should be doing is advising you on the effectiveness of those terms and conditions and what they mean for you. If you then want me to get involved and negotiate a higher package, that can, if it's a lengthy amount of negotiation, become a separate bit of advice. Now, let me dissect that further for you. So, for example, when you go through the payment clause, it will also explain the termination payment in detail. So you will get told how much you are going to get paid. Now, this is the only time usually where the fee that is being paid to the person that's checking it, such as myself, that they can get involved, but up to a certain point. So for example, if there is outstanding holiday pay which is not listed in the termination payment, and you say, yes, you have 25 days accrued that you never took for the whole year, which equate to £4,000, which is a month's salary effectively, then that should be raised with the employer by the lawyer to say, can we have that added in? If the termination payment, for example, has accidentally been written down as something you have to pay national insurance and tax on, when you've been told that it will be tax-free, then that is something also that the lawyer should contact them and say, look, that term needs to be altered because as per the instructions my client received, this has been added on for payment with tax and national insurance, so please can you change this? Or, for example, there may be some bonus missing that you were promised, which was £50,000 at the back end of all the sales that you did last year in your role. That needs to be added in. Now, sometimes employers add these in and sometimes they don't because they've already added them in, or they will send the information separately in an email. I always say it's good to get the employer at least have a clause within the agreement which then refers to this additional email which lists out all the additional benefits that you will get. Some of the payment sums may not be able to be listed in the termination payment at that stage, for example, accrued pension or some other bonus, for example, because it's not yet been calculated. But it's always worth making sure that your lawyer adds those sorts of points in. I always have to explain this to a lot of clients who come to me because sometimes people misunderstand the fee that is being paid by the employer. A lot of people feel that the fee that's being paid by the employer is going to cover independent legal advice about whether or not they have a case. Now, I advise many clients this, but I also speak to many fellow colleagues in the legal profession, and I always say tread carefully here, because sometimes employees will come with the settlement agreements and a lot of lawyers will go over and above to help them to see whether or not they've got a case. But if at the end of that advice the employee turns around and says, actually, you know what, I'm not going to take this settlement agreement, then you don't have anything in place to actually charge that client. And secondly, the other issue is you've given advice which actually has not really been documented and is not going to be paid for either. So I think it's a very interesting aspect of settlement agreements, and there's a fine line between how far should a lawyer go. However, the important part is that the money paid by the employer is very different. The money paid by the employer is to seek advice and to understand the clauses and the effectivity of that agreement, not for you to go and seek out if you have a case. Now, the other thing to watch out for is sometimes a lot of lawyers that you may go to will say, okay, we're happy to tell you whether or not you've got a case. Let's have a look at how much your employer is paying. Oh, they're only paying £250 or they're paying £500. Please read the terms and conditions of that client care letter, because the terms and conditions may say advice upon a settlement agreement or advice as to whether or not the settlement agreement should be taken. They are two separate things. Make sure you understand what you are seeking advice for. If a settlement agreement has become a point of discussion for you, and if you are an employee or an employer, please come and talk to me in the free 15-minute sessions. You can self-book these on my website, www.thedirectaccessbarrister.com. I am Haresh Sood, and this is Pancho.